In this season of episodes, I am discussing general introduction and origin of criminal law along with the introduction of Indian Penal Code. As of now, we have discussed origin of criminal law, development of modern criminal law in India, a scheme of justice adopted by Warren Hastings, Regulating Act of 1773, Charter Act of 1833, drafting of Indian Penal Code, mental elements in crime, and types of punishment in Indian Penal Code. In today's episode, I am going to discuss about the theories of punishment. There are four theories of punishment that is being mentioned or applicable in Indian Penal Code. What are these theories? Number one, deterrent theory. Number second, preventive theory. Number third, retributive theory. And number fourth, reformative theory. The purpose of the first two principles, that is deterrent theory and preventive theory, is to prevent crimes by punishment. Generally, this punishment is given keeping in mind the nature of the crime. But sometimes this punishment is more than the nature of the crime, whose only purpose is to frighten the general public so that they become alert and fearful of crimes by seeing the innocent being punished. But retributive punishment was given with a sense of revenge. Whoever commits the crime, he would have got the same punishment. The purpose of this punishment was life shall go for life, hand for hand, foot for foot, eye for eye, and tooth for tooth. This was a brutal and unnatural form of punishment which is not given today. In today's welfare state, the reformative purpose of punishment is considered more useful and important. The aim of correctional theory is to make the criminal a good human being. Under this comes the education of criminals in prisons, teaching industrial work, etc. Father of the nation Mahatma Gandhi used to say, man is not bad by birth, but circumstances make him bad. Therefore, keeping the criminals away from these evils and making them good human beings should be the aim of the correctional punishment. The purpose of corrective punishment is based on his statement that we should hate the sin, not the sinner. We should hate the crime, not the criminal. Crimes should be thoroughly investigated and punished because uninvestigated criminals are an expensive luxury, which means it is a very expensive entertainment to punish without investigating crimes. To launch these punishments, to apply these theories of punishment, there should be a criminality test so that it can be proved that whether a person is innocent or guilty. There are mainly two elements of criminality test. What are these elements? Number one is physical element and number two is mental element. Both these elements are used to test the criminality not only in England but also in India. These elements originated from the following two sources. Number one is no person shall be deemed to be guilty of an offense unless he was in a criminal state of mind at the time of doing the act. And number second is the presumption of innocence of the accused until proven guilty. Later, the first formula was presented as follows: it is a principle of natural justice and also of our law that a person cannot be convicted by more act unless his mind is also guilty. So that's all for today. And you can say that this is the last episode of this season of Indian Penal Code, in which I have discussed the introduction of Indian Penal Code and along with the general introduction of criminal law. I will be soon coming with the next season of Indian Penal Code, in which I will take you forward to the fundamental elements of crime. We will be discussing the general principles of criminal law, and we will move towards the sections and chapters of Indian Penal Code.